Welcome to today's deep dive. We are on a mission to unpack a really compelling legal narrative today about the tension between desperate parental hope and, well, strict medical ethics.
Yeah, it's a heavy one. We are bringing you insights from a detailed breakdown of the 2026 Supreme Court of India judgment, Yash Charitable Trust versus Union of India.
To really grasp the weight of this case, you have to imagine the human stakes involved here. When a family receives an autism spectrum disorder diagnosis for their child, they are desperate for progress.
Right, they just want their kid to thrive, and then they see, a slick advertisement for a clinic promising a stem cell miracle cure.
And families in this exact situation have been paying exorbitant fees.
Literally lakhs of rupees.
Yeah, lakhs of rupees, just out of sheer desperation, hoping for a breakthrough.
But the core conflict really hinges on that desperation. Clinics aggressively market these therapies as a routine cure, but the global scientific community and the ICMR, the Indian Council of Medical Research, explicitly classify them as purely experimental.
Okay, let's unpack this, because the legal mechanics of how these clinics defended selling an experimental treatment are wild.
They attempted a very bold maneuver using a technical loophole. Under Section 3B of the Drugs and Cosmetics Act of 1940, the clinics claimed that because they were using autologous stem cells—
Meaning the patient's own tissue, right?
Exactly. They claimed it couldn't legally be classified as a drug. They argued they were just processing your own cells, so they should be exempt from medical regulation entirely.
I mean, the audacity of trying to argue that your own body parts, once processed and sold back to you, aren't subject to medical oversight is just something else.
The Supreme Court obviously didn't buy it. They ruled that any substance intended for the treatment of a disease is legally a drug.
So the moment your cells are weaponized as a commercial treatment substance, that triggers strict mandatory licensing.
What's fascinating here is how the court leveraged the Bolam Test to shut down these clinics.
Oh, right. For those of you familiar with medical law, the Bolam Test is the ultimate benchmark for determining medical negligence.
It basically dictates that doctors must adhere to accepted medical practices.
And if the ICMR clearly states that stem cells for autism are unproven, a doctor offering them as a routine service is completely ignoring those established guidelines.
Which means they fail that standard of care. The court declared their actions to be blatant professional misconduct.
No, I think we need to slow down a bit for this next part, because we have to look at the most philosophically delicate aspect of this case, which is the defense of informed consent.
Right. The clinics threw out a massive constitutional argument here. They claimed that under Article 21, the right to life, parents have patient autonomy.
The defense was essentially that parents have the fundamental right to choose these treatments and freely signed consent forms to do so.
But the court dismantled that argument using the precedent from the Samiracoli case. That ruling firmly established that for consent to be legally valid, a patient has to be given adequate information about the risks and benefits.
And if a treatment is entirely experimental, the scientific data on those risks versus benefits simply does not exist.
You cannot consent to unknown variables. Because the science is unproven, doctors cannot legally or ethically provide that required adequate information.
So any consent form signed by those parents was fundamentally worthless.
Exactly. The ruling makes it incredibly clear that patient autonomy does not give anyone the right to demand unscientific treatments.
And it absolutely does not act as a shield for doctors exploiting vulnerable families either. You cannot weaponize a parent's desperate hope as a legal defense.
Bringing this back to the real world, the practical takeaways here are critical. For the general public listening, beware of pricey miracle cures.
If a clinic demands massive amounts of money for an experimental treatment, run the other way. Legitimate clinical trials are rarely paid services.
And for the legal and medical professionals tuning in, the message is just as stark. Innovation cannot bypass regulatory frameworks.
Disregarding ICMR guidelines isn't just frowned upon, it is a fast track to malpractice and losing your license.
This judgment goes far beyond just banning a single specific therapy. It represents a complete redefinition of safety and ethics in modern Indian medicine.
So what does this all mean?
It means the Supreme Court has drawn a hard line in the sand, prioritizing the protection of vulnerable people over predatory marketing disguised as medical innovation.
Leaving you with a final thought to ponder. If the law is practically always playing catch-up with science, how do we protect desperate patients from tomorrow's unproven miracle cures that aren't even on the regulatory radar yet?